So the difference between physical and legal custody is that there's two parts to what we talk about as custody. Physical custody would be more like parenting time. It's the days and overnights that you get to naturally parent your child, that they are primarily in your physical care. But legal custody has to do with decision making. Who's going to make decisions about education, religion, and other major decisions, medical decisions, things of that nature. Some common schedules for parenting time, that physical custody aspect, are to split time 50-50. And sometimes that looks like week on, week off. That's usually more appropriate for older children. Or it can look like 5 days with one parent, 2 days with the other, 2 days with another, and then 5. It would be like mom has 5 days, dad has 2, mom has 2, dad has 5. That's a 50-50 arrangement as well. And there are arrangements where one parent, usually due to work schedule, will have children every other weekend or every weekend, and then maybe a dinner visit. But most typically, courts try to, with safe parents, split time equally in a way that facilitates both parents naturally being able to parent their children. A lot of times people talk about best interests of the child. I'll get comments that the courts really aren't looking after the best interest, but these are statutory. There's actually a list that the court is required to consider about what best interest is. In high level, it is both parents' ability to show love and support for the child's other relationship with their other parent and their family, to make sure that the child is being cared for properly, that they have, the ability to ensure their educational needs, community needs, as well as taking into account, when appropriate, what the child desires. Now, the court's not going to let the tail wag the dog when it comes to kids choosing. A big question I get, and very often, is at what age do kids get to choose? At no age do kids get to choose. That's why they have parents. But kids do get to weigh in when they're of sufficient age and maturity to do so. That's a question that's either decided by the parents or the court. In certain instances, it is appropriate to go back to the court and change custody. Obviously, if your child is endangered by the current parenting plan, that would be a time where you would want to go back in. But sometimes people enter into custody arrangements, especially either the court entered one when the children were very little, or you had an agreement when the kids were little that really just doesn't apply. Your kids have gotten older. Maybe you didn't take into account the sports activities that kids are involved in. Also, if parties move, like initially you set up a 50-50 because you lived in town, but now it's a 45-minute commute or states apart, it's important to go back and, modify those plans. Parents absolutely should try to do this themselves, but best practice would be to get that new arrangement in writing and have the court adopt it, even if as a stipulation. It's absolutely possible to move with your child. I would caution you, though, even if your court order doesn't expressly state it, it's not usually a good idea to up and move with your child over the objection of the other parent. That can actually trigger things like the court entering orders to return the child to the state. We see Amber Alerts. Those sometimes get issued because one parent's just decided to move away and the other parents sought abduction prevention assistance from the court. And the request to move from county to county is not what I'm talking about. This typically applies to moves that substantially changes the location of the child with respect to the other parent. For instance, if you live in Nashville and you want to move to Knoxville, your ex lives in Brentwood, you're going to be able to do child exchanges, enjoy a 50-50 living there. But if you move to Knoxville, that's a 3-hour drive. There's no way you're going to be able to follow the same 50-50. In terms of how long it takes to get these things done, that's very dependent on the court. Courts have motion days, different dockets. My suggestion to you, if you're contemplating this kind of move, is to get in with an attorney as soon as possible so that they can evaluate, the strength of your arguments for having the child move with you, and you can ask that question well in advance of when you actually want to go. Custody questions Parenting time and decision making are arguably, at least in my opinion, the very most important questions in a family law case. And many of them are much more nuanced than you might imagine. If you need help navigating a custody situation, give us a call and we'll be happy to help you navigate that path.